On this production from Jail to Yale, we're just going to cover a little bit here, inequity and why it's so important. Excuse me. So, the United States of America's genius but costly established private trust mortgage arrangement established under the rules of equity chancery signed by multiple jointers and witnesses intended for the posterity, and it secures and protects your unalienable beneficial rights. Unfortunately, through ignorance and neglect, nobody also told you that private trust chancery practices and laws, not commerce, govern the essence of the entire Western world since Jesus Christ brought the new covenant. And the best news is that you can enforce these very rights today from your private personal conduct all the way to the Supreme Court of the United States. However, also, since this day of your nativity or naturalization, operating upon you without your knowledge or your consent, are only two competing realms of law, at law or in equity. The written law versus the unwritten law, the enumerated law versus the unenumerated law, the fictional realm versus the substantive realm, the at law versus the equitable jurisdiction. The objective during the next couple hours here is to help you see that and realize how glorious equity is. On the one hand, there is commerce, war powers, public at law, and on the other hand, there is equity, private, substantive, unalienable doctrines and principles. It's about understanding new laws and guiding principles from a massive established volume of jurisprudence called equity. This realm shall be your new realm as a practicing, unincorporated private citizen of the United States and private member of one of the Union member states, privately residing and privately domiciling without a federal zone improvement project number, within a non-military occupied private area not subject to the jurisdiction of the Roman Military Municipal United States, Title 28, 3002, 15A, Washington, D.C., District of Columbia. Okay, so we're identifying here. All right, I am not a citizen of the District of Columbia. Furthermore, many of you are not. And for those of you that were unfortunately born there, there's a way to come up out of her. Okay, it's a bad position. You're going to have to go back to Virginia, and there's another state that they split in half or ceded land to Washington, D.C. for it to exist. Remember, there's only 50 stars on the flag, and technically there should only be 48 stars. That's another story for another day. However, what I want to point out to you is Washington, D.C. is not a state, okay? There's Virginia and West Virginia. Anyway, moving on. Definitions of winning. Private decree arising from private confesso decree in chancery, exclusive and original jurisdiction under the rules of equity. Now, equity existed long before they created the Declaration of Independence, the Bill of Rights, the Constitution, the Federalist Papers. Equity has always been prevalent. Men have just been oblivious to it, all right? Be it in any state or federal equitable jurisdiction. Equity history. Aristotle, equity. Aristotle had said, equity is the correction of the general words when matters fall outside of their senses. Joseph Story, thus Aristotle has defined the very nature of equity to be the correction of the law, wherein it is defective by reason of its universality. Bible, New Testament, New Covenant. The story of the stoning of the adulterous woman, Jesus used God's conscience, mind, to judge, not the common law, Pharisees, or Roman martial law, or military law, military rule, by way of force. Okay, he chose not to use those laws and rather took God conscious and applied equity. The law of first mention from Matthew 3:15, the first use of the word righteousness, which is a Greek word, out of the dictionary meaning equity of character or act, specifically character, justification, righteousness. In Ecclesiastes 2:21, equity or kasher a prime root, proper, to be straight or right, by implication to be acceptable, also to succeed or prosper, direct, be right, prosper. Proverbs 1:3, to receive instructions in wise behavior, righteousness, justice, and equity. Proverbs 2:9, then you will discern righteousness and justice and equity and every good course. Psalms 98:9, for he cometh to judge the earth with righteousness, shall he judge the world and the people with equity. Announce that I am free of all the charges against me. Only you can see into my heart to know that to be true. Treat me with fairness. Look at me with justice. Psalm 17:2. Let my sentence come out of your presence. Let your eyes look on equity. Psalm 17:2. Psalms 72:2. May he judge your people with righteousness and your afflicted with justice. May he vindicate the afflicted of the people, save the children of the needy, and crush the oppressor. For he will deliver the needy when he cries for help, the afflicted also, and him who has no helper. Sometimes the same word is rendered in one version, equity, and in another, uprightness. Psalms 111:8, or justice, Psalms 89:14. John Bouvier, Institutions of American Law, 1882, Volume 2, subsection 3724, par 4. The law is nothing without equity, and equity is everything, even without the law. Those who perceive that it is what is just and what is unjust only through the eyes of the law never see it for what it really never see it as well as those who behold it with the eyes of equity. Law may be looked upon in some manner as an assistance for those who have a weak perception or right and wrong. In the same way, the optical glasses are useful for those who are short-sighted or those whose visual organs are deficient. Equity in its true and genuine meaning is the soul and spirit of the law. Equity exercises an exclusive jurisdiction in all cases of mere equitable rights. That is, such rights are not recognized in courts at law. Most of the cases of trust and confidence fall underneath this head. Its exclusive jurisdiction is also exercised in granting special relief beyond the reach of the common law. Okay, the common law is not good. Ex equato et bono is a Latin term which means what is just and fair, or according to equity and good conscience, something to be decided. Ex elque et bono is something that is to be decided by principle of what is fair and just. A decision maker who is authorized to decide ex elque et bono is not bound by legal rules but may take account of what is just and fair. Most legal cases are decided on a strict rule of law. For example, a contract will be enforced by the legal system no matter how unfair it may prove to be. But a case to be decided ex equo et bono overrides the strict rule of law and requires instead a decision based on what is fair and just under the given circumstances. Maxims are rules or principles of the law universally admitted as being just and consonant with reason. I would say consistent with reason. They are something like axioms in geometry. Many maxims are merely the statement, in short, of pithy sentences, of principles which claim the assent of mankind. These existed before the law, for it has been well observed, nations have been found without laws, none have been found without maxims. Such maxims may be considered as a fragment of the natural law, which was promulgated at the beginning of the world. Maxims of the law, Bouvier's 1856 Law Dictionary. An heir, one who succeeds to the whole inheritance. God and not man make the heir. Heir is a collective name. Heir is a term of law, son, one of nature. An heir is either by right of property or right of representation. An heir is another self, and a son is a part of the father. The heir is the same person with the ancestor. The heir of my heir is my heir. He is the lawful heir whom the marriage demonstrates. The heir succeeds to the restitution, not the penalty. When two rights concur in one person, it is the same as if they were two separate persons. Bouvier's Maxims of Law, 1856. To make a law, there must be a superior who has the authority to make it, and an inferior who is bound by it. To complete the definition of law, we must say that it is a rule prescribed by a lawful superior. God is the first superior. Institutions of American Law, Volume 1, 1851, by John Bouvier. Henry R. Gibson, Suits and Chancery, 2nd edition, 1907, Tennessee. Henry Richard Gibson, December 24th, 1837 through May 25th, 1938. Served as a state chancery court judge and was delegated to Tennessee 1870 Constitutional Convention. Outside of politics, he wrote and edited several books on federal and state laws. Subsection 3, the delegation of authority was made in the year 1348, and in the next 50 years, the equity jurisdiction of the chancellor was clearly established. Subsection 5, equity ignores fiction. The common law was then utterly incapable of doing complete justice in many cases, and in not a few cases, it furnished no remedy or relief whatever. It had certain rigid molds or formulas, into some one of which every cause of action had to be cast. And if the cause could not be run into any of these molds, there was no redress. And if it could not be run into one of these molds, only such redress as the formula gave could be had. Regardless of the equities of the case and the real rights of the parties, the fiction formalisms and arbitrary technicalities of the common law and its dialectical refinement were inexplicable and incomprehensible jargon to the public, and often a costly mockery of justice to the litigants. Those who asked for bread were often given a stone, and those who applied for a fish sometimes received a serpent. Equity, on the other hand, disregards form, ignores fiction, subordinated technicalities to the requirements of justice, and indulges in no dialectical refinements. Its pleadings were simple and natural, and its doctrines were founded upon the eternal principles of right as interpreted by a lofty Christian morality. Its great underlying principles, the constant source, the never-failing root of its particular rules, were the principles of equity, justice, morality, and honesty, enforced according to conscience and good faith, and so adapted to the requirements of each case and the complications of business affairs, that the rights and duties of all the parties were fully determined. Blind justice, with sword in one hand and scale in the other, condemning all in one scale and rewarding all in the other scale, is the divinity of the courts at law. The divinity of the courts of chancery, on the other hand, is open-eyed equity, having neither sword nor scale, wearing the breastplates of good reason and good conscience, using both hands to remove all forms, cloaks, veils, technicalities, and subterfuge that conceal or distort the real facts and circumstances of the case before her, separating the pure grains of truth from the straw and chaff of fraud and artifice, and apportioning to each party, whether complainant or defendant, what is good reason and good conscience is his just due. Subsection 35, Chancery has been the handmaid of all the courts in affording processes to meet exigencies. She has done so in the face of tyranny, to break loose the iron hand of power when grasping against consciousness. Blackstone's died in 1780 before the valued lessons of mature experience in equity's limitless field were fully learned. Spoonshacket case. Commentaries of the Law of England were written and published 1765 through 1768, and Blackstone died in 1780, before the valued lessons of mature experience and equity in limitless field were fully learned. And it was a full century later that Parliament adopted its equity guarding amendment of the English Judicature Act of 1873, amended in 1875. The equity jurisdiction in the modern 21st century state courts. 1957 Supreme Court of Michigan, Hacks versus Concrete Wall. Maximum equity follows the law. This maximum equity follows the law uniquely, unlike equity's remaining maximum, is limited in its application and operates within very narrow limits. Adverting to Pomrey, First Pomrey's Equity Jurisprudence, 4th edition, subsection 427, page 796 through 797, the maximum is, in truth, operative only within a very narrow range. To raise it to the position of the general principles would be a palpable error. Throughout the great mass of its jurisprudence, equity, instead of following the law, either ignores or openly disregards and opposes the law, as well as was shown in that portion of the introductory chapter which deals with the nature of equity. One large division of the equity jurisprudence lies completely outside of the law. It is additional to the law, and while it leaves the law concerning the same subject matter in full force and efficiency, its doctrines and rules are constructed without any references to the corresponding doctrines and rules of the law. Another division of equity jurisprudence is directly opposed to the law, which applies to the same subject matter. Its doctrines and rules are so contrary to those of the law that when they are put into operation, the analogous legal doctrines and rules are displaced and nullified. This is Hack versus Concrete Wall, docket number 89. Supreme Court of Michigan decided October 7th, 1957. Rehearing denied. November 26, 1957. As to Robinson, we apprehend that it is more accurate to say that the case has never been challenged or overruled, and it fully sustains equity broadly exercised jurisdiction where the related remedies and reimbursements, exonerations, contributions, or subrogations are properly invoked, whether the suit be termed one for reimbursement or otherwise, the reason underlying equity's jurisdiction are the same. Pomrey says 5 Pomrey's Equity Jurisprudence, 4th edition, Equitable Remedies, 2nd edition, subsection 911, page 5162 through 5163 in general. Under the early jurisdiction at law, in the absence of express contracts for indemnity or exoneration, it was left to the caprice of the creditor to determine upon which of several parties bound for the same obligation the burden should fall, the loss being left wherever the creditor, by his choice of a defendant, might put it. This inadequacy of remedy on the part of the victim and consequent failure of justice became, however, a ground for the interposition of equity, and the proper readjustment of such burdens was, at an early day, an important field of equitable jurisdiction. The efforts of the courts of equity have been directed towards placing the loss as far as possible on the parties ultimately liable, or between two or more not ultimately liable on the party whose liability is prior, and as between parties equally liable, towards distributing the loss equally among them, or equally amongst all the men involved. The former results is researched by an action for reimbursement, and the latter by an action for contribution. Both of these results are assisted by the action for exoneration and the remedial process of subrogation. The text just quoted make up the lead paragraph of chapter headed Suits for Reimbursement, Contribution, Exoneration, and Subrogation, section 920, page 5183. In the chapters in the chapter pursues our search to fulfill, and we quote, subrogation. When an obligation is discharged by not only by one not primarily liable for it, but who believes himself to be acting either in performance of a legal duty or for the protection of a legal right, or at the request of the party ultimately bound, and even in certain other cases favored by the public policy, where none of the above circumstances may be present, the party thus discharging the obligation is entitled in equity to demand for his reimbursement, and subject to any superior equities the performance of the original obligation and the application thereto of all securities and collateral rights held by the creditor. The same equity which seeks to prevent the unearned enrichment of one party at the expense of another by action for reimbursement, contribution, and exoneration operates here by creating a relation somewhat analogous to the constructive trust in favor of the subrogee, or party making the payment. In all legal rights held by the creditor, and the subrogee may proceed to enforce the trust. In the second place, and this we affirm with emphasis, the right of appeal to equity by proper bill, and the right or review de novo of an equity case, and that's a trial de novo from the beginning, okay? Or a review by de novo, so from the beginning, of an equitable case, are just as sacred as the right of trial by jury. Equity looks specially to the intent and seeks evidence with respect thereto. Law limits its inquisitions to logistical forms and rights. The acoustically sensitive walls of equity cathedral are turned to being sound law cannot hear. And witnesses regularly speak to chancellors of circumstance deemed irrelevant in common law courts. She imputes intention to fulfill express or implied obligations, whereas the same obligation may not be enforceable elsewhere for sometimes primitive legal reasons. Her chancellors seek to provide and ensure fair dealings when the forms of the law are sometimes supine and lifeless. Though equity customarily follows the law, it is not so slavishly nor always. Generally, in all matters in which there is any conflict of variance between the rules of equity and the rules of the common law with reference to the same subject matter, the rules of equity shall prevail. First Pommery's Equity Jurisprudence, 5th edition, page XXIV. Equity shall not erode so long as her defenders stay vigilant. Pommery, same page. With all these plaintiffs have properly and vainly insisted upon determination of their asserted rights in equity, and having duly brought the questions to us for review, this court is bound to uphold the bills they have filed as against defendants said motion. The fact is that an order for transfer from equity to law or law to equity is properly reviewable by application and grant of leave in nature of mandamus. Okay? Huge golden nuggets here, folks. Pommery, subsection 297, effect of state laws. On the other hand, the affirmative form of the rule has always been uniformly asserted and maintained that the equitable jurisdiction exists and will be exercised in all cases and under all circumstances where the remedy at law is not adequate, complete, and certain, so as to meet all the requirements of justice. That there is a legal remedy is not enough. The test of the relative jurisdiction over suits at law and in equity are: 1. The subject matter; 2. The relief; 3. Its application; 4. The competency of the court of law to afford it. Palmary preface, equity jurisprudence. Some of these principles are so comprehensive and fruitful that one who has grasped them in their fullness of conception has already mastered the system of equity. All else is the mere application of these grand truths to particular circumstances. The Judicature Act of 1875, generally in all matters in which there is any conflict of variance between the rules of equity and the rules of the common law, with reference to the same subject matter, the rules of equity shall prevail. Rudsill versus Whitener, 146 North Carolina 403 1907, Supreme Court of North Carolina, generally in all matters in which there is any conflict between the rules of equity and the rules of law, the common law, with reference to the same subject matter, the rules of equity shall prevail. And I'm going to skip ahead because there's about 15 cases that all say the same thing. Idaho, Michigan, South Carolina, New Mexico, they're all saying the same thing. This is Mississippi, Montana, they're all agreeing. West Virginia, they're all agreeing that anytime there's a conflict between the rules of equity and the rules at law, the rules of equity will prevail. Minnesota, here's another case out of Minnesota. It says, conflict between legal and equitable rules. It is provided by statute in England and in some of the code states of this country that where there is a conflict of variance between the rules of equity and the rules of the common law with reference to the same subject matter, the rules of equity shall prevail. We have no statutes in this state, but where there is such a conflict or variance, or courts apply our courts apply the equitable rule. The exclusive equity jurisdiction is not ousted by statute or else by any express term or clear and necessary implication. Equitable jurisdiction, once having attached to a case, will be maintained for the final adjudication of all rights involved. Charles Phelps, Judiciary Equity, subsection 268. Federal Article 3. Citizens of the District of Columbia were not granted the privileges of litigating in the federal courts on the grounds of diversity of citizenship. Possibly, no better reason for this fact exists than such citizens were not thought of when the Judiciary Article 3 of the Federal Constitution was drafted. Citizens of the United States were also not thought of. But in any event, a citizen of the United States who is not a citizen of any state is not within the language of the federal Constitution. Pennell versus Roanoke, 252 F 910, 914. This was in the District of Columbia, Virginia, 1918. We therefore decline to overrule the opinion of Chief Justice Marshall. Justice Marshall is huge, guys. Huge. We hold that the District of Columbia is not a state within Article 3 of the Constitution. In other words, cases between citizens of the district and those of the states were not included of the catalog of controversies over which the Congress could give jurisdiction to federal courts by virtue of Article 3. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington, D.C., the District of Columbia, and through their plenary power nationally covers those citizens. Even when in one of those several states, as though the district expands for the purpose of regulating its citizens whenever they go throughout the state in union. National Mutual Insurance Company of the District of Columbia versus Tidwater Transfer Company, 337 U.S. 582-93 LED 1556 in the year 1948. Palmary, subsection 296, illustrations. The four foregoing principles may be justly regarded, I think, as the very foundation of equitable jurisdiction of the United States courts. They give it whatever peculiar character it possesses, growing out of the double organization of a national and state governments, and they clearly distinguish it from the jurisdiction possessed by any state tribunals. In the particular administration of their equitable power, the national judiciary have constantly affirmed and steadily adhered to the doctrine in its negative form that the equitable jurisdiction does not exist, or will not be exercised in any case or under any circumstance where there is an adequate, complete, and certain remedy at law, sufficient to meet all the demands of justice, which I can assure you, it's never happening at the at-law side because they're administering the bankruptcy, and it's never, ever, ever in your favor. It's never in your favor. Now, somebody drew something very important to me today as I was studying. And they said, yeah, Derek, they did away with the gold standard. They never did away with the silver standard. And I said, oh, you see, gold was a rich man's game. And silver was more the middleman's game, and then there was the paupers, the impoverished, that were trying to earn a dollar here and there where they could. And I really have to reevaluate my stance after he said that, because I never, ever, ever thought about that. You see, the true dollar is defined by 371.24 or 25 grains of silver. And when I realized that although they abolished the gold standard, they never did away with the private money on the private side. Fantastic news for us. Fantastic news. And it just the conversation that I had with him this evening really lit me up. I was like, oh, this is awesome. This is cool. So my studies are not going to waste. All right. A private American heir beneficiary is legally disabled and is prevented from any adequate remedy under the provisional emergency, all right? So that's the War Powers Act. It's the national banking emergency. We're always under it. We've always been in a time of, okay, let's not call it military martial law. Let's call it military rule. And military rule is ruled by deception all the time to gain that pleading edge, that leading edge in order to, always be one step ahead. Look, we don't want the military to be sloughs. They're always going to be one step ahead. It's a game of chess, guys. So all you got to do is correct your political status. And your political status is very, very simple. I'm not a United States citizen. I'm not a belligerent enemy combatant of the United States. I'm a friend. I'm not a neutral. I'm not an enemy, because if you're a neutral, you're an enemy. Can't be neutral. There is no neutral. You have to pick a side. It's really simple. You're either going to be at the at-law side and be subservient to them and yes, sir, yes, sir, yes, sir, and obey their orders and play with their trickery and do their forms, or you're going to be on the private side where you are sovereign and you have sovereignty, okay? And you just have to make that heartfelt decision to change your mindset. Really that simple. Once you get your passport and your name decree and all these things put in order, you don't need anything anymore from these people. In fact, they're going to want to contact you. They're going to want to be talking to you because you're the creditor, okay? You're the beneficiary. You have all the power, and they would love to borrow some power from you to do some really good things. Example of negative form letter from Master based on the true events. In reply to your letter, I regret that the court is unable to assist you in this matter you present. Under Article 3 of the Constitution, the jurisdiction of this court extends only to cases brought before it from the lower court. Translation: the public court will not handle your matter, but as a master of the private side, where Article 3 is recognized, I require you to cure a small defect of the lower court record where I can see what the defendant did with your removal. Story, subsection 743 and 744, form versus substance. The federal judge is authorized to be a chancellor in equity in the USA, pleading in practices of High Court of Chancery by Edmund Robert Daniel. By the original Judiciary Act, and now by the U.S. Revised Statute, Section 913, the forms and modes of proceedings in suits of equity in the U.S. courts shall be according to the principles, rules, and usage which belong to the courts of equity. And the settled doctrine of the U.S. Supreme Court is that the remedies in equity are to be administered according to the practice of courts of equity. In England, the parent country from which we derived our knowledge of them, FN2 Chapter 1, page 1, subsection 11, 16, and 20 of the Judiciary Act of 1789, First Congress, Session 1, Chapter 20, 1789. The High Court of the Judicature, 1873 through 1875, aka the Judicature Act, that is implemented in the Judiciary Act, that is brought forward as the conflict of variance of the law, that is mandatory judicial cognizance, and that the source of your authority is not statute, and the authority of the Emergency Banking Relief Act does not apply to you or I or anybody else, nor do I consent to it. All right, but you have to give notice, don't you? Because everything in equity is notice and opportunity, and by default, by failing to assert who you are, naturally you're an infant, incompetent ward of the state. Okay? It's just by default. It's for your protection. Don't hate me. I'm just the messenger. But I'm here to tell you, if you don't make a claim like a man and let them know that you're not an infant of unsound mind and unknown parentage, and that you fully are alive and you're an adult and you're competent to handle your affairs over all other men, and you're going to just let them know. You're just going to give them a simple notice of interest, statement of interest, all right? By legal construction, in applying the maximum, and I'm not even going to try and read it in Latin. It's too late. It's too late in the day for me to even try that. My eyes are hurting. The inclusion of one is the exclusion of another. So you see what I'm talking about when I'm telling you that if I'm not a United States citizen, well, to exclude one includes the other, right? Is an inclusion of the other. So if I'm not a United States citizen, well, then what am I? Well, I'm just a man, first and foremost. But if I'm going to draw a political allegiance to something, maybe I'm an Arizonan, okay? An Arizonan, part of the Union States, okay? That has a constitution that protects my unalienable rights, that's tied directly to me as an heir and assign, as a beneficiary, as a grantee absolute. How do we prove that? Well, we got to read on. And vice versa. The exclusion of the Emergency Banking Relief Act is the inclusion of my right under the Judiciary Act of 1789, Chapter 11, 16, and 20, and Supreme Court of Judicature. Justice Joseph Story, in his book, Equity is the Fountain of Justice, Limitless Grace. It is the source of all law. I mean, just think of how wonderful that is. Joseph Story, studying under John Marshall, one of the youngest perhaps ever to come out underneath of this and be writing major books on equity. Brilliant. Three heads of equity. There's auxiliary, concurrent, and exclusive. All right, auxiliary, concurrent, and exclusive. Do not call the courts looking for a court of equity. It's not how it happens. It's on the four corners of your paper. We've all been telling you this for quite some time now. The jurisdiction is all about the words that you put on paper cast spells. Okay, they're powerful. It's not to be playing around like you're Harry Potter and you're running around like little Mary Poppins going bibbity bobbity boop. You don't want to do that shit because you get spanked for it. All right, be in there with intent, be serious, let them know that you're serious, let them know that you're there in good faith with clean hands to do the wonderful works of the Heavenly Father, and to see that justice is done, and to see that all parties are made whole, and to make sure that the situation is handled honorably, and take care of it, right? Very simple. So, do not call the courts looking for a court of equity. Military doctrine of plausible deniability. It's not a courtroom, okay? It's your paperwork. And rights in judge private chambers. Martial court not in session. So private chambers in camera. And they do a bunch of different little things. Sometimes they leave the door open. Sometimes I've been in a situation where I personally walked through a different set of doors than the public doors. It was pretty cool. Like I explained to my mom, and the more I teach her, the more I show her, she realizes how powerful, how special that really was. They said, Mom, you're probably the only gal in Nebraska that's ever got to walk in with a man into the exclusive jurisdiction of Equity in Chambers and got to witness it, even though you didn't understand what was going on. That was a very, very special moment. And we're getting ready to have another one. So I got some choices to make about what I'm going to do here. Because if I'm going to be a public nuisance on the public side, I may not be able to enter the glorious place, the Star Chamber of Equity. So I really have to think this one out, this upcoming case that I have going on. Because I know what I'm doing and I know what I'm talking about. And I'm not saying that I have all the answers. It's, a brilliant mind's like a parachute. It only works when it's open. So I have to be teachable. And like I tell you guys, a lot of these magistrates, these judges, they're giving you hints. They're dropping them. They're very, very particular about the words they use. They're not mincing their words. I used to think they were just complete asinine idiots. And the more I study and the more I go back and kind of review what they said to me, how they wrote stuff down, and I'm looking at it and I'm like, sometimes they'll break the law just to give you a remedy, just to see if you're going to apply yourself to figure it out. It's kind of like one of them little game cubes, and you got to get all the colors lined up. And they'll give it to you right in the paperwork. And to prove that, I had a lawyer once tell me, Dirk, all your remedies right there in the first page of the paperwork. It's all right there. It's all right there, Dirk. And that's all I can tell you. I can't tell you anything else. And he just walked away. And I just kept staring at this paper going, I don't get it. But you apply yourself, you start to study, and things start to come out on the paper. You start to see the anomalies. You start to see the errors. You start to see the things that need corrected. And then I discovered equity. And it's like, ooh, this is fun. And I've been studying equity for a minute now because I've been doing other things with the FDCPA, which really does tie back into equity. But at the same time, I didn't have a case of my own. Now I have a case of my own. I want to go back at this a different way. Just knowing the wonderful realm of equity. Okay. Not cognizable in public, anywhere in the public. Enemies, belligerents, rebels do not get constitutionally protected exclusive equity presided by a true chancellor in chancery. All right. If you're an enemy, belligerent, rebel, combatant, I promise you're not getting in there. If you're a neutral, I promise you're not getting in there. You must be a friend. It takes two hands to wash. They need you as bad as you need them. We're not supposed to be enemies. We're not supposed to be trading with the enemy. But there are some things that are in the works here where equity prevails. Because equity is a time traveler. It'll go all the way back to 1776 to fix the wrong that maybe one of our founding fathers made. All right. If you can identify equity, go back there and correct it. Unenumerated protections in the Constitution, Ninth Amendment. The Ninth Amendment to the United States reads, to the United States Constitution reads, the enumerated in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. All right, the people. Ladies and gentlemen, you're so powerful. We're just blinded by this military occupation, this military rule, this military force that lives over us at this point. And unfortunately, due to our education system, if law is so important in every facet of our life for our entire existence, and even beyond this existence, I have to believe after studying this, that there is still law when your spirit continues to travel on, that energy continues to travel on. There is still a law in nature that we must follow. That's how interrupt this breaking story with a development. Facebook decided to try and censor me there. They said I don't have any internet connection, which is, well, you know what it is. Professor John Norton Pomeroy, equity is in full force. Pomeroy, subsection 354. To sum up this result in one brief statement, all equitable estates, interest, and primary rights, and all the principles, doctrines, and rules of the equity jurisprudence by which they are defined, determined, and regulated remain absolutely untouched. Whew. Man, that's powerful. In their full force and extent, as much as though a separate court of chancery were still preserved. Ladies and gentlemen, he's just telling you right there that they can never touch it. They can never change it. No matter how much they want to alter it, they can't do it. You are superior in equity. All right? Section 355 in Palmery 1905 to say that the distinctive modes of equity procedures are alone abrogated by the legislator, while the principles, doctrines, and the rules of the equity jurisprudence and jurisdiction are wholly unaffected. While the external distinction of form between the suits in equity and actions at law have been abrogated, the essential distinction which in the very nature of equitable and legal primary or remedial rights still exist as clearly defined as before the system was adopted, and most continue to exist until the peculiar features of the common law are destroyed and the entire municipal jurisprudence of the state is transformed into equity. Equitable remedies, Palmery, section 357, page 591, on certain equitable remedies. While it is undoubtedly true that with the exception just mentioned of the right conferred upon the direct assignee of a legal thing in action, all the equitable estates, interest, properties, liens, and other primary rights, one recognized by the equity jurisprudence, and all the principles, doctrines, and rules of that jurisprudence which define them, determine their existence, and regulate their acquisition, transfer, and enjoyment, are untouched and unaffected. Gibson Suits in Chancery, 1907, Equitable versus Statutory, subsection 23 through 25. The equitable or inherent to include all those matters, whether purely equitable in their nature or having characteristics both equitable and legal, jurisdiction over which is derived exclusively or chiefly from their inherent powers as courts of equity, and the statutory to include all those matters, whether equitable in their characteristic or purely legal in their nature, jurisdiction over which is derived exclusively or chiefly from our statutes. Equitable inherent is purely equitable by nature, equitable by characteristic, legal by characteristic. Okay, that's the equity side. Statutory is purely legal by nature and equitable by characteristic. 1. The private citizen holding purely equitable title. 2. The bank or government holding inferior equitable title. 3. Private citizens holding a trustee title of a private trust, military title or commerce, or federal rules of civil procedure, criminal, United States Code, or the IRS, etc. Same as number 3 above, but it's superior title under statutory authority. Gibson, subsection 25, exclusive or inherent equity cases include the following: all suits resulting from accidents and mistakes, all suits resulting from trust, express, constructive, and resulting, all suits for the reformation, re-execution, rescission, and surrender of written instruments, all suits for an accounting and for surcharging and falsifying accounts, all suits for the administration and marshaling of assets, all suits for the enforcement of liens created by mortgages, deeds of trust, sale of land on credit, or other equitable considerations, i.e. the equity of redemption upon a mortgage. All right? All suits by wards against guardians, executors, administrators, and others, where an accounting or surcharging or falsifying an account is necessary. All suits for the marshaling of securities, all suits for relief against forfeitures and penalties, all suits for the redemption of land or other property, all suits to have absolute deed or bills of sale declared to be mortgages, all suits for the construction and enforcement of wills and trust, all suits for the discovery and perpetuation of testimony, all suits for equitable attachment and receivers, all suits where an injunction is a substantial part of the relief sought, all suits to remove cloud on quiet title, all suits for a new trial after a judgment at law, all suits to have void judgment so declared and to avoid voidable judgments, all suits to prevent the doing of an illegal or inequitable act to the injury of complainants, property rights, or interest, all suits for the exoneration or protection of sureties. All other suits where the defendant has done or is doing or is threatening to do some inequitable act to the injury of the complainant, and there is no adequate remedy therefore in any other court. Gibson, subsection 445, presumption of law. Presumptions are either conclusive or disputable. Conclusive presumptions will yield to no proof, however strong, but disputable presumptions may be overcome by proof. An illustration of conclusive presumptions of the law may be mentioned: that everyone knows the criminal law, that every sane man contemplates the probable consequences of his own acts, and that everyone has knowledge of a deed duly registered. Gibson, subsection 73, priorities. Where there is equal equities, the law must prevail. Priority of rights, where the equal equity, the law must prevail. In a court of chancery, in a conflict of equities, the party having the superior equity will prevail. And if the equities are equal and neither party has a legal title, then priority prevails. And if no priority, then the defendant prevails. Gibson, subsection 47. Quasi-trustee is the same pleading as a trustee. Husband, wife, parent, person in a perpetual situation, attorney, guardian ad litem, next friend, partner, agent, business manager, clerk, steward, secretary, treasurer, bookkeeper, auctioneer, consignee, bailey, physician, spiritual advisor, the promoters, president, directors, and other officers or managers of a corporation or association, vendor, creditor, principal, debtor, in case of suretyship, and, in general, all other persons who undertake or assume the character of confidential advisor or managers of another's affairs, or whom occupy a position or relation that enables them to greatly influence the actions of those relying upon them, or who in any way acquire influence and abuse it, or possess another's confidence and betray it. The term trustee includes both trustee and quasi-trustees, and the term beneficiary denotes and includes everyone who expressly or impliedly confides or trusts his property, business, or affairs to another, and everyone for whose benefit an express or implied trust arises, or a constructive fraud can be declared. Volunteers and imperfect titles. Consent. Every man is independent of all laws except those prescribed by nature. He is not bound by any institutions formed by his fellow men without his consent. Crunden versus Neal. This is North Carolina, 338, May term, 1796. Inasmuch as every government is an artificial person, an abstract, and a creature of the mind, only a government can interface only with other artificial persons. The imaginary, having neither actuality nor substance, is foreclosed from creating and attaining parity with the tangible. The legal manifestation of this, that no government, as well as any law, agency, aspect, court, etc., can concern itself with anything other than that of corporate artificial persons and the contracts between them. Penhallow versus Dones, Doanes, Administrator, Dones Administrator. 3 U.S. 54, 1 LED, 57, 3 Dallas, Texas, I'm guessing, 54. 1795 would be the year. Gibson, subsection 74, volunteer without consideration. Teacher's conclusion. All commerce springs from volunteering, creating imperfect titles, waiving private, defaulting to the public, and volunteering without consideration to hold assignment of duties and debts of an artificial person. All commerce originates from two equity maxims. Equity will not aid a volunteer. Equity will not complete an imperfect gift. Leviticus 2:25. You shall not receive any imperfect things from a stranger to make it the Lord's offering, which he calls the bread of the Lord. In the name of the Lord I accept. Otherwise, it's in the name of the state. Black's 8th edition, volunteer. The grantee is a voluntary conveyance, a person to whom a conveyance is made without any valuable consideration, see voluntary conveyance under conveyance. Black's Law, first edition, volunteer. In conveyances, one who holds a title under a voluntary conveyance, one made without consideration, good or valuable, to support it. Reports of cases in law and equity in the Supreme Court, 56 by Oliver Lorenzo, Barbauer. A court of equity will not aid the defective execution of a power in favor of a volunteer. First story equity jurisprudence, subsection 176. It is quite clear as a general rule that where a person shows the clearest intentions to give, but leaves the gift imperfect, let the subject of it be what it may, the court of chancery will not interfere at the instance of a volunteer to make it perfect. 1846, equitable jurisdiction of a court of chancery. Although equity will not aid a volunteer, it will not strive auspiciously to defeat a gift. George Spence, whereas an agreement or an attempt to assign is in form and nature incomplete, the origin of the transaction must be inquired into by the court, and where there is no consideration, the court, upon its general principles, cannot complete what it finds imperfect. Lord Eldon, if you are a volunteer, you shall not have the help of a court of equity to make you a cestacea trust. Palmery, subsection 755.2, time of giving notice. We have seen that if notice is not given until after the purchaser has fully paid the consideration, received a conveyance, and completed his title, he is not in the least affected by it. Guy in your house after foreclosure has to complete his title, or he is a volunteer, and you can go back and snatch it up. Acceptance is perfection. Corpus Juris Secundum. Parties. Book 67A, subsection 30. Necessity for accepting judgment. Persons for whose benefit the action is brought cannot claim the benefit of the judgment without coming in some way and accepting it. However, it has been held that in derivative action, it is of no importance whether or not those entitled to share in the recovery are made plaintiffs. Benefits and privileges. Maximums of benefits and privileges. Favors from government often carry with them an enhanced measure of regulation. Anyone may renounce a law introduced for his own benefit. No one is obliged to accept a benefit against his consent. He who receives the benefit should also bear the disadvantage. He who derives a benefit from a thing ought to feel the disadvantage attending it. He who enjoys the benefit ought also to bear the burden. He who enjoys the advantage of a right takes the accompanying disadvantage. A privilege is, as it were, a private law. A privilege is a personal benefit and dies with the person. One who avails himself of the benefits coffered by statute cannot deny its validity. What I approve, I do not reject. I cannot approve and reject at the same time. I cannot take the benefit of an instrument and at the same time repudiate it. He who does any benefit to another for me is considered as doing it to me. Gibson, subsection 62, he who enjoys the benefit ought also bear the burden. Valuable consideration, Palmery, subsection 747. What is valuable consideration? What constitutes a valuable consideration within the meaning of the doctrine which gives protection to a bona fide purchaser? No person who has acquired title as a mere volunteer can thereby be a bona fide purchaser. Gibson, subsection 75. Vendee must be legally worse off. Valuable consideration means and necessarily requires, under every form and kind of purchase, something of actual value, capable in estimation of the law or pecuniary measurements. parting with money or money's worth, or an actual change of the purchaser's legal position for the worse. The amount of the purchase, if otherwise in good faith, is not generally material. Gibson, subsection 43. Hence, it is the passing of the consideration and not the form of the contract that in equity passes title. Okay, are you paying attention to that? Remember, in 1933, they did away with the gold standard. They didn't get rid of the silver. You got two coins that help perfect and transfer title. And I bet none of you guys did this at closing with a bank. You slide a piece of silver and give them that valuable consideration. Create that trust. Do an acknowledgement and acceptance of the warranty deed. Skeet. Should have done it. Still can. Equity is a time traveler. You can still do it. All right? So anyway, Gibson's subsection 43, hence it is by passing of consideration and not form of the contract that in equity passes the title. So it's that valuable consideration. It's that silver coin, ladies and gentlemen. You got the Morgan silver dollar and the Liberty dollar, I believe, are the two coins that were minted. All right. The American Eagle, although 999 pure, that is not actually a coin minted for the United States of America. So just think about that. The coin that we're talking about. And actually, I'm going to take that back, because in all actuality, in equity, we're going to go back, clear back before 1776, actually, and we're going to look at what they were using for value back then. It was 371.24 grains of silver. It was a coin. So I believe that's a true troy ounce. I could be 100% off beaten path here, but I believe that is a true troy ounce. If somebody out there has got the math on that, let me know. Bouvier, 6th edition, 1856, subsection 20. To convey a title, the seller must himself have a title to the property which is the subject of the transfer. But to this general rule, there are exceptions. What are those exceptions? Well, you don't have to put everything on a public record. You don't have to register everything, and your record on the private side supersedes the record that they have on the public. All right? So, the lawful coin of the United States will pass the property along with the possession. A negotiable instrument endorsed in blank is transferable by any person holding it, so as by its delivery to give a good title to any person honestly acquiring it. Maxims of equity. Equity maxims existed before the law, page 459, Institutes of American Law by Bouvier, 1870, section 3726. Maxims are rules or principles of law universally admitted as being just and consistent with reason. These existed before the law, for it has been well observed, nations have been found without laws, none without maxims. Such maxims may be considered as fragments of the natural law, which was promulgated at the beginning of the world. Equity sees that as done what ought to be done. Equity will not suffer a wrong without a remedy. Equity delights in equality. One who seeks equity must do equity. Equity aids the vigilant, not those who slumber on their rights. Equity imputes an intent to fulfill an obligation. Equity acts in personam, which means one-on-one, mano a mano, in person, in camera, in chambers, all right? Equity arbors a forfeiture. Equity does not require an idle gesture. He who comes into equity must come with clean hands. Equity delights to do justice and not by way of halves. Equity will take jurisdiction to avoid multiplicity of suits. Equity follows the law. Equity will not aid a volunteer. Equity, where equities are equal, the law will prevail. Between equal equities, the first in order of time shall prevail. Equity will not complete an imperfect gift. Equity will not allow a statute to be used as a cloak for fraud. Equity will not allow trust to fail for want of a trustee. Equity regards the beneficiary as the true owner, and a quasi-maximum here. He who occasioned the loss must bear the burden. Latches. If you wait too long to enforce your right, then your right stale over time. Where the federal equity jurisdiction is exclusive and it is not exercised in aid of a legal right, state statutes of limitations barring actions at law are inapplicable, and in the absence of any state statute barring the equitable remedy in like cases, the federal court is remitted to and applies the doctrines of laches as controlling. Page 309 U.S. 289 U.S. Supreme Court, 1940. Equitable Assets, Joseph Story, Commentary of Equity Jurisprudence, 1888, page 565, section 552, Definitions of Equitable Assets. Equitable assets are, on the other hand, all assets which are chargeable with the payment of debt or legacies in equity, and which do not fall under the description of legal assets. They are called equitable assets because, in obtaining payment out of them, they can be reached only by the aid and instrumentality of a court of equity. They are also called equitable for another reason, and that is that the rule of distribution by which they are governed are different from those of the distribution of legal assets. In general, it may be said that equitable assets are of two kinds. The first is where assets are created such by the intent of the party. The second is whereby they result from the nature of the estate made chargeable. Thus, for instance, if a testator devises land to a trustees to sell for the payment of debts, the assets resulting from the execution of the trust are equitable assets upon the plain intent of the testator. Notwithstanding, the trustees are also made his executors, for by directing the sale to be for the payment of debts generally, he excludes all preferences, and the property would not otherwise be liable. And the property would not otherwise be liable to the payment of simple contract debts. The same principle applies in the testator's merely charges his land with the payment of his debts. On the other hand, if the estate be of an equitable nature and be chargeable with debts, the fund is to be deemed equitable assets, unless by some statute it is expressly made legal asset, for it cannot be reached except through the instrumentality of a court of equity. Latches. If you wait too long to enforce your rights, then your rights stale over time. Where the federal equity jurisdiction is exclusive and is not exercised in aid of a legal right, state statute of limitations barring action at law are inapplicable. And in the absence of any state statute barring the equitable remedy in like cases, the federal court is remitted to and applies the doctrine of latches as controlling. Page 309 U.S. 289 U.S. Supreme Court, 1940. Private trust law express trust, 14th century crusaders, king's conscience over land, use fiefment and rights to rents and possession. Palmery, Perry, Gilbert, Lewin, element of trust, intent, purpose, parties and res, or trust residue, residual. Method of formation, intent, manifestation, manifested intent. Purpose, lawful purposes, not legal, necessarily lawful. We're not using statutes, codes, city ordinances, rules, and regulations to build a statutory trust. We're in the exclusive jurisdiction of equity, building a private trust that all men would be able to comprehend and understand, of almost all ages, all right? Parties, rechargeable and beneficiary is identified. Parties are reachable and the beneficiary is identified. And last but not least, trust res. Methods of formation, delivery, transfer, verbal, fraud, concealment, conveyance, contract, agreement, will, statute, silence, acquiescence, admission, consent, acceptance, endorsement, appointment, failure of disclaimer, notice, registration, recording endorsement, and declaration. Such a trust may be created by deed or may rest entirely in parole, a simple parole agreement and contract, or may be partially in writing and partially in parole. 1966, Florida Appeals, Frazier versus Frazier. Gibson subsection 44, and when it is shown that such person have used money by them so held in trust in the purchase of any property, real or personal, taking the title in their own name, a court of chancery will impute to them an intention to fulfill their obligation, namely to make the purchase for the benefit of the person entitled to the use of the consideration money, and they will be decreed to hold such property as trustees for the benefit of the parties whose funds were used in the purchase. And there's an interesting story that goes with that, but I'm not going to tell it today. But it's about a lawyer and a man who privately learned the law, and his buddy was getting married for the second time, and he said, "Look, instead of a prenup, should something go horribly wrong, and I'm not hoping or wishing that it does, but I'm just looking out for you. You're my man, and I study law a lot, and I'd like to help you to make sure that your assets are in trust, and so you own nothing and you're just the trustee. And the reason that we're going to do that is because if she decides in 2 years down the road that this isn't the marriage that she thought it was going to be, it isn't heaven like it once was, puppy love is over, the honeymoon stage is gone, buddy, I want to make sure you don't lose everything like you lost the first time. Even though you had a prenup, it didn't matter because they went in there and they chopped that thing up." But he says, "I'll tell you what they can't chop up. They can't chop up a trust. And if it's done properly, privately, in the exclusive jurisdiction of equity, they won't be able to take anything from you." So they did. They found a lawyer that would step away from the bar card for a few days over the weekend, and they put this beautiful trust together. And it wasn't 2.5 years later, this woman went to file for divorce. It got so brutal and so nasty that she called the cops on him and tried to have him removed from the house. Well, the cops wouldn't remove him from the house, but she didn't understand why. And so they go to court over it. And they get to court, and she tells the judge, "I want the house. I want the car. I mean, he could take a duffel bag full of clothes, but he needs to get out of here." And the judge says, whoa, wait a minute. You got this thing in chambers here, and he doesn't own the house. And she says, "Oh, yes, he does. We're married. I know he owns that house. Judge, I know he owns that house. We've lived there the whole time. I know he owns that house." And the judge says, "Well, I got bad news for you. He don't own the house. He's the trustee." And he immediately looks over at the trustee and says, "Trustee, what do you want done? What do you need done?" Well, he says, "Well, in the interest of protecting the trust and the assets on behalf of the beneficiary, I need that woman to be vacated from that home immediately, effective immediately, to make sure that she doesn't cause any damage that would harm the beneficiary or cause harm, injury, damage, and loss to the trust." So he says, "It's so ordered. Ma'am, you're to get out of there today, immediately. Bailiff, see to it that she gets out over that location and packs her stuff right away and gets out of that location, out of that house, just like that, because he didn't own it. He's just the caretaker. He's just the trustee, and he had a fiduciary responsibility to the beneficiary to make sure that woman wasn't going to be in there destroying things because she thought he owned it. All right, he had a duty to make sure she wasn't going to be vindictive, and the chancellor had a duty to enforce the trust, because the construction of the trust indenture is the law of the trust, and it must always be enforced, period, so long as nobody's operating outside the trust, which is brilliant. You don't start a trust for houses and decide to start lodging cars in it, okay? It's not what your trust was intended for. You want to do one for cars, you want to have all your eggs in one basket, you want to start multiple trusts. There's nothing wrong with that. All right. Another story. It's kind of sad. A very, very famous actor who dealt with a lawyer who created trusts. Okay. And he got in a wreck in an Enzo Ferrari. Any of you guys know what an Enzo Ferrari is? It's like $1 million car. Okay. And he got in this horrible wreck and he killed a family of 5 in a minivan. And one of them survived that wreck. And you know what they were entitled to? Because of trust, they were entitled to a wrecked Enzo Ferrari. Okay. Because everything else was in different trusts. He didn't have everything all in one trust. Okay? Had he had everything in one trust, he'd probably lost his multi-million-dollar houses and his bank accounts and estates and things of that nature, because it would have been able to pierce the veil of the trust. But because he had that car in its own trust, and I presume and assume at this point that he had every little facet in a different trust protecting it, the only thing they were entitled to was a wrecked $1 million Ferrari. Okay? Let's move on. That's the power of trust. Okay. And that's why I study trust so much. And I'm getting better and better and better as time goes on. I don't know everything there is to know. Your mind works best when it's open. So just keep an open mind. Implied trust. Edward C. Halbach, Jr., Gilbert Law Summaries, Trust, author of second and third restatement on trust used widely in courts today. Special note, implied trusteeship without consideration. Gilbert's, subsection 274, notice to and acceptance by trustee. And an effective transfer has been made. If an effective transfer has been made, a valid trust exists, even if the trustee has not been made aware of it. Neither notice to nor acceptance by the trustee is essential to formation of a trust. Ladies and gentlemen, when they're bringing claims against you and they're really complaints, they've created a trust. You just got to identify it. You just got to get the judge to see it. It's a trust. It's a trust. There's no consideration. I'm going to bring a consideration with one silver coin. I'm going to bring the value in consideration. You sent the documents. We're going to pay the taxes on it. It's a trust. It's a trust, okay? It's hard to wrap your head around this stuff because it really is magic. It's wild. It's so wild. But in equity, it's like the workings of the Heavenly Father. It's so powerful. Gilbert's, subsection 276. The trustee acceptance is presumed unless the contrary is shown, okay? It's about intent, ladies and gentlemen. You got to make your claim. Prove your intent. Ask them if they're disclaiming the trust. Put your piece of silver on that puppy and buy it. They don't have any credit. You got to ask them if they're insolvent. They got to respond to you if they're solvent or not. If they're not solvent, then how are they bringing a claim? Because they've got to indemnify you. Huh? Yeah? Okay. Following me? They can't bring no claim if they ain't got no nada. It don't work that way. Gilbert, subsection 276, the trustee acceptance is presumed unless the contrary is shown. The trust cannot be forced upon him. However, and he is free to disclaim the trusteeship any time prior to accepting it. Might be the first thing you want to do when you walk in there. I grant the name to the court and I absolutely equivocally disclaim being the trustee. Not today, Satan. Ain't happening. All right. Gilbert, subsection 276, 282. Recording without notice, the failure to inform the intended trustee had no significance and that an irrevocable trust was created. Gilbert's, subsection 276, acceptance presumed. The trustee acceptance is presumed unless the contrary is shown. The trust cannot be forced upon him, however, and he is free to disclaim the trusteeship anytime prior to accepting it. That's rest 3D, subsection 35. Gilbert, subsection 277, disclaimer. If there has been an effective transfer, but the trustee disclaims before acceptance, the trust does not fail for lack of a trustee. Rather, a court holds that title remains in the settler subject to the trust until a substitute trustee is appointed. Gilbert, subsection 279, trustee's obligations. Once having accepted the trustee is bound by all of the fiduciary obligations imposed by the law and by the terms of the trust, and can be held personally liable for neglect. See infra, subsection 611 through 620. Registration alone does not Resignation alone does not relieve the trustee of these duties and responsibilities. Ordinarily, the trustee must petition the court for a replacement. Even if the trust instrument expressly authorizes resignation, the duties of one who has accepted a trust continue until a successor is in place. That's rest 3D, subsection 36. Gilbert's, subsection 280, acceptance relates back. The trustee acceptance normally relates back to the time of the trust came into being. Gilbert, subsection 281, duties prior to acceptance, although for many purposes, ergo, accrual of beneficiaries' rights to benefit or to benefits. A trust becomes effective at the time it comes into existence. The trustee normally has no fiduciary duties until acceptance of the trusteeship, expressly or implied, occurs. Gilbert, subsection 282, notice to and acceptance by the beneficiary. Notice to the beneficiary that the settler intends to create a trust or has created one is not necessary is not necessary for a valid trust. Acceptance by the beneficiary also is not essential to trust formation. Rest 3D subsection 14. Waters Law of Trust, DWM Waters, 1984, second edition, page 672. Implied acceptances is normally established by the conduct of the would be appointee. If the person in question deals with the trust property of any part of it, and there is no explanation clearly linking his acts to another purpose, he will thereby impliedly accept the trusteeship. But there is a different reason in deeming an appointee to have impliedly accepted the trust when he deals with the trust property. It is not his dialect tort, but his actual assumption of the task to which he has been appointed, which makes him a trustee. No technical words are needed. Gilbert's special private priority in confidence. Trust created by any actual transfer of legal estate and property from one to another, or as it was afterwards called, by transmutation of possession, the equitable jurisdiction of the Court of Chancery, 1846. Private trust is enforced in exclusive equity. All right. Remember earlier we were talking about auxiliary. It's been a long night. There's auxiliary, the exclusive jurisdiction of equity, and there was one more. The concurrent jurisdiction. I believe it was concurrent. I'll have to go back and look. Suretyship, agent principal. Suretyship is equity, but it is also public side too. The big lesson below is you want to be an agent and not a principal surety. Here's the biggest thing. The agent can bind the principal in a contract. Agent principal, you are the agent, and the birth certificate, all caps, is the principal. Gibson subsection 47, the term quasi-trustee denotes and includes principal debtor in cases of suretyship. Because the surety is the principal debtor, if the principal obligee does not perform. Subsection 52, misconduct of the trustee agent, bingo, the trustee can have an agent. Subsection 52, money in the bank, he chose the agent or attorney and he loaned the money. The maximum applies also to cases where an agent has been given apparent authority to sell goods or do any act, and taking advantage of his apparent authority sells the goods or does the act in fraud of the principal's rights and misapplies the proceeds. In such cases, the loss fall not on the party who deals with the agent, but on the principal. Subsection 52, where a party signs a forged note as surety, believing the principal's signature thereto genuine, and the payee parts with the value for such note, the party so signing as surety must bear the loss. Corpus Juris Secundum, section 739, Bills and Notes, book 11, signing as agent. Personal liability in accordance with a Negotiable Instrument Act, section 20, where an accommodation signer merely adds words describing him as an agent or representative without disclosing his principal, the agent will be held personally liable. Subsection 60, footnotes. A man's property is, in a sense, a part of himself, and when his property is seized by another, he is presumed to know it. The property being in the possession of him or agents, and the knowledge of the agent being considered the knowledge of the principal. Subsection 62, quae facit per alumni facti. Way too late. It's not too late in life to learn Latin. It's way too late in the evening to be trying it. So let's go on. He who does anything by another does it himself. The act of the agent is the act of the principal, and among partners, each one is the agent of all others. If the principal, so notice the principal is notice the agent is notice the principal, you picking up what I'm laying down here? or master ratifies an act of his agent or servant, the effect is the same as though such act was expressly authorized before it was done. Subsection 65. Notice to agent when notice is notice to an agent when notice to his principal. Notice to an agent in the business or employment which he is carrying on for his principal is a constructive notice. Okay, so we've identified what kind of notice it's going to be. It's going to be a constructive notice that we're sending to him. A notice of interest, a statement of interest, and a constructive notice to the principal himself. So far as the latter's rights and liabilities are involved in or affected by the transaction, this rule alike includes and applies to the positive information or knowledge obtained or possessed by the agent in the transaction, and to actual or constructive notice communicated to him therein. The general rule that notice to agent is notice to principal will operate with equal force and effect whether the notice to agent be actual or constructive. Actual knowledge may be brought home to get the agent by the most direct evidence, or he may be chargeable with constructive notice by a lis pendens, by a registration by recticles in title deeds, by possession of the property by a stranger, or by circumstances sufficient to put a prudent man upon inquiry. In all such cases, the effect upon the principal is the same as though the information or notice to the agent had been to him in person. So notice to one partner is notice to the other as to partnership matters, but not as to individual matters. All right? So in business matters, notice to agent, notice to principal is notice to everything. But in private matters, individual matters, a little bit different. Might have to notify all the parties involved. Names, Gibson, subsection 271, footnote. If the coin be gold, a wrong name will not, If the coin be gold, a wrong name will not make it brass. The name is a mere tag. Names are mutable, but things are immutable. No baptismal name is required for a bill, and no plea of misnomer will lie to it. Maximum. Equity looks to the intent rather than the form. The Moloch of formality erected by the law and on whose iron altars justice has been so often sacrificed, has never profaned the temples of equity. There is no magic in forms or names in the court of equity. An error of name amounts to nothing when there is certainty as to the thing itself. The presence of the body does away with the mistake in the name. And I quote that maximum a lot. I just quote it different. The error in the name. The presence of the body waives the error in the name. That's how I announce it. So, same thing. The bill being in the hands of the chancellor, its praenomen is wholly immaterial. That word's going to bother me. He will judge it from his allegations. The code does not require a bill to have any Christian name. Notice and its effects. He who buys with notice of another's rights is bound in good conscience to hold what he buys, subject to those rights, for otherwise he would be taking advantage of his own wrong and would be enriching himself at another's expense, neither of which act is permitted by a court of conscience. Maximum. He who seeks equity must do equity. Unregistered equitable claim, Palmary, subsection 659. In other words, if a subsequent purchaser, for a valuable consideration, has put his conveyance upon record, but at the time of his purchase was affected with notice that there was a prior outstanding but unregistered conveyance of the same premise from the same grantor, would he be protected by his record notwithstanding the notice? Or would the notice operate like the constructive notice arising from a registry to postpone his own interest to that conferred by the prior unregistered instrument. This question was presented in the English courts of chancery at an early day, and was settled by them in accordance with the general principles of equity, and their decision have with great uniformity been adopted and followed by the American courts in its courts. It is the established doctrines that a notice of some kind of an existing prior unrecorded conveyance, operates like the constructive notice arising from a registry. Amen. Hallelujah. All right. Check that out. Just going to prove that you don't have to register shit with the dirtbags on the public side. Okay. To postpone a subsequent and a record instrument, if a subsequent purchaser, even for a valuable consideration, had received notice of a prior unrecorded instrument, then he cannot acquire or retain the precedence from a registration of his own conveyance. His conveyance through record is subordinated and postponed to the prior unrecorded one which he had received notice. Special deposit versus general deposit banking. I place this on special deposit with you. The suit is plainly one of equitable cognizance, the bill being filed to charge the defendant as a trustee for a breach of trust in regards to special deposit. Argued March 14th, 15th, 1889. Decided in April 8th, 1889. Bank of Memphis versus Eliza Walker. The general rule is that every person who receives money to be paid to another or to be applied to a particular purpose to which he does not apply it becomes the trustee and is answerable to the owner of the money as for a breach of trust. In regards, Introborough Council Co-op, a trustee is bound only as he accepts the trust, but the trust is not invalidated by his failure or refusal, while his dismissal while his disclaimer frees him from any obligation to execute the trust. The rights of the beneficiary are in no sense dependent upon his acceptance. A court of equity will never suffer an express trust, in regard to which there is no question, to fail for lack of a trustee. Beach, 1897, Trust and Trustees. The writing, meaning the declaration of trust, are but evidence the trust is anterior and independent, and the rights which the courts regard are those that spring from the creation, not the mere proof of the trust. McAvey versus McAvey, 1887, Supreme Court, New Jersey. 5. Primary Office of Trust. Grantee holds unimpeachable, indefeasible, root primary title, both legal and equitable, both sides of the ledger, all liabilities, all assets, both the beneficiary and the trustee at the same time. Grantor settler. When the grantee title will be split to the legal trustee and equitable beneficiary. Trustee receives legal title from grantee, express or implied. Beneficiary receives equitable title from grantee, express or implied, and the heir maximum. Only God can create an heir, and an heir stands in the rights of his ancestors. The king never dies, i.e., heir to a decedent's legal estate, birth certificate. Mode of acquiring root title, alienation, which is the conversion of your rights. It's the alienation is to, how do you want to say it? Well, alienation is alienation. You're going to have to look it up, but it doesn't mean what you think it means. It's to convert your rights, okay, from one to another. That's alienation. One mode of alienation is by mere written agreement. Another is by deed, that is, by a writing sealed and delivered. A third mode is by matter of record. An unimpeachable title, or root of title, might be obtained in favor of or by a purchaser for value. First, a compendium of the law of real and personal property, primarily connected with conveyancing by Joshua W. Smith, retired judge, Volume 1, 6th edition, 1884, page 631. Until a deed is accepted by the grantee, the title of the estate does not pass out of the grantor. Okay? For no man can make another his grantee without his consent, and a deed made to a man with all requisites, formalities, and even entered in the public registry will be null if not afterwards accepted by the grantee. You guys know how many times I've been preaching and teaching to you guys to get back to the courthouses and do an acknowledgement and acceptance of your warranty deed. Your lawyers ain't going to tell you this shit. The people selling you property and real estate ain't going to tell you this shit. They don't know it. They don't care. They're in a big club. They're compartmentalized. They don't have any ambition to further aspire to be greater than what they've been taught. They've plateaued. They're making six figures and they're happy. All right. They have no lust or desire to learn this shit. And because they have no lust or desire to learn this shit, they ain't going to teach you about it either. All right. This is stuff that you find when good men in this country have been stood up and walked all over. And we finally go, you know what? We're not going to beat them with bullets, blades, and hand grenades. We're going to have to beat them with books. And we're going to have to get intelligent. And this is going to be a task and a feat in itself. But I will say this process has most definitely made me a better man. I'm more calculated on the things I do. I'm more thoughtful. My dealings with people have changed. The way that I speak, my mannerism, the way I carry myself, completely different than it used to be. All right. So with that said, this is a good thing. Quit looking at it the negative. We're just trying to get to the top of Mount Everest. That's all we're going to do. And we're going to carry each other up to the top of Mount Everest to the best of our ability. And we're going to get up there to that point where if you make a mistake, it's imminent death and nobody can save you because you are your savior. All right. We're going to get up there to the point where you're almost to the peak of Mount Everest and you got to put your oxygen on. You got to have your brain about you and you're going to have to navigate through the trickery of what these people are going to try and do to keep that estate from you, because they're going to try. They're going to try all kinds of stuff to keep you from ascending in the mind. If you were to go into a court and start talking about the things that I'm showing you right here, they would laugh you out of it and you would feel about that big. You know, man, that guy, he's talking all this stuff and I was there and they just laughed at me. Equity doesn't always happen before your eyes. Sometimes it's what's going on in the background. It's not like they're going to take you out and parade you around on the 6 o'clock news. Lord knows they didn't do it for me. They're not going to go out there and put you on the radio. By God, this guy, he's a great man in your community. You guys are so lucky to have him. It's not going to happen that way, ladies and gentlemen. They are not going to do that for you. All right? I just want to let you know that you ain't getting no pat on the back saying that a boy. You might get a smirk out of a chancellor. You might get all right, thank you very much. Have a good day. That's about as good as it's going to get. You ain't going to get, yeah, we know exactly what you're doing. Sit down here. We'd like to help you. That ain't happening. That ain't happening. I'm going to tell you that right now. If you're going into this thinking that you're going to nail it out of the park on the first go-around, just know I don't think anybody could do that. I don't think anybody could do that. I don't even think people out of law school that were studying this could hit it out of the park like that, because it takes thought process. It takes time. You could speak it. You could speak it quicker than you could probably write it because it's written on your heart, and you could speak it, and in equity, you can manifest whatever into existence so long as you're being honorable about it and you're doing the right thing, and you could speak it into existence. And they might act like they're not hearing you. They might ignore you. They might say denied. Don't think of that as a loss. Keep your mind open. Keep thinking, because just because they said it was denied doesn't mean they ruled on it, okay? They didn't rule on it. They just denied it. They're providing you a remedy. They're giving you a ticket to go to the next big venue to enforce your rights, all right? Because rights are enforced by the vigilant, okay? Not from the ones that stand idly by and watch them disappear and dissipate. Until a deed is accepted by the grantee, the title of the estate does not pass out of the grantor. For no man can make another his grantee without his consent, and a deed made to a man with all requisites, formalities, and even entered in the public registry will be null if not afterward accepted by the grantee. Maximum. Equity will not aid a volunteer. Equity will not complete an imperfect gift. So all you people going through foreclosure, cloud on title, what else do those little tricky bastards pull? The cloud on title is a pretty good one. They do that cloud on title a lot. You're giving them the opportunity to do that by not acknowledging and accepting your warranty deed. By not calling and getting a hold of the bank and requiring them to put on record on the abstract filing of the land record the letter of satisfaction, completion of mortgage, all that stuff, and merging everything together. Merge your legal and equitable title together and collapse that trust. Give it some valuable consideration to an acknowledgement and acceptance of it. Becoming the grantee absolute. Then remove that sucker from the tax roll. Turn around and remove the lot, block, parcel ID number, zone improvement, project number, address. Pull it all off of that crap. Stick it all in a P.O. box for them. Go, there you go. There's your shit. Get your shit off my land. Don't want it. Don't need it. Don't need your benefits. Don't wish to be a military occupied zone. Need a none of that. All right? Until a deed is accepted by the grantee. Okay, we already went through that. All right. A delivery always implies an acceptance by the person to whom the delivery is made, and although where a deed or mortgage or an instrument purporting to be such is properly acknowledged and recorded, the presumption is that it has been duly delivered to the grantee or mortgagee, and that it is, in legal effect, what by the record it purports to be, yet such presumption is only prima facie evidence and may be rebutted by parole or other evidence and shown never to have been delivered. Oops. When a grantor causes an acknowledged deed conferring substantial benefits on the grantee to be recorded, there can be no doubt that it will afford a prima facie evidence and even stronger presumption evidence of a delivery to and acceptance by the grantee, but such presumption can be overcome by evidence that no delivery in fact was intended and none made. Deeds creating a trust delivered to a third person or recorded by the grantor have been upheld, although there was no actual acceptance by the trustee. The person named as trustee never heard of or saw the deed until long after it was recorded, and then refused to accept the trust or in any way to act upon it. The court held that his refusal was immaterial, saying although the trustee may never have heard of the deed, the title vests in him, subject to a disclaimer on his part. Such disclaimer as a transfer of the equitable interest to a third person. A trust cannot fail for want of a trustee or by the refusal of all the trustees to accept the trust. The Court of Chancery will appoint new trustees. Lawyers report annotated. Note, legal fiction can only hold title by characteristic, and a private American national citizen part of the Union States only holding title by nature, and a title by nature extinguishes a title by characteristic in any court of equity. Mortgages are equity because they are primarily two reciprocating trusts. It is also an established doctrine that an equity of redemption is inseparably connected with a mortgage. That is to say, so long as the instrument is one of security, the borrower has in a court of equity a right to redeem the property upon payment of the loan. This right cannot be waived or abandoned by any stipulations of the parties made at the time, even if embodied in the mortgage. This is a doctrine from which a court of equity never deviates. 1877 Supreme Court of the United States, Pughh versus Davis. What is valuable consideration for a mortgage? What did you receive for what you gave? Loan application, notice of approval. They are holding credit assets, grant deed, lien, mortgage, contract, note, clogging provisions, landlord-tenant relationship, improvements, man security. Although the mortgagor is equitable owner, yet the mortgagee is more than a trustee for him, for the trustee is not allowed to deprive the Sestake trust of his possession, but a mortgagee may assume the possession whenever he pleases. If there is no agreement to the contrary, and in point, the possession the mortgagor is tenant at will, even in equity, for a court of equity never interferes to prevent the mortgagee from assuming the possession. Coote, Coote versus on mortgages, 379, page 324. And with that, ladies and gentlemen, I don't know what time it is, but we got to go a little further. We got to go a little deeper. Commerce is simply shadow titles not claimed in the private, titles that someone did not perfect their private title to. Equity will not complete an imperfect gift. Equity will not aid a volunteer. Shadow titles, Pommery, subsection 47. The ownership of equitable estate is regarded by equity as the real owner, and legal estate is, as has been said, no more than shadow always following the equitable estate, which is the substance, except where there is a purchase for value and without notice who has acquired the legal estate. The private citizen objective, the end game, the merger. Merging of titles, the doctrine of merger is when legal and equitable titles vest in the same individual entity. When whole title is achieved, the beneficiary becomes the grantee, the trust terminates. Here's many ways merger happens when title vests in the same entity. A higher right and a lower right over the same subject matter, the lower right is extinguished. When an easement is acquired by the incumbents C, the easement is extinguished. A big one here. When a debtor becomes the beneficiary of the debt, the debt is extinguished. All right, we'll get over my little dun-da-duns. When one withdraws from general deposit and redeposits on special deposit, the same subject matter, the relation changes, all right? The relation change, the lower relation is extinguished. Debtor-creditor is extinguished and special confidence relations are left. When a beneficial right by nature of a living man claims the beneficial right of a legal fiction over the same subject matter, the higher right wins by nature, because rights by nature trump rights by characteristic. When legal title when legal title by nature of a living man is assigned to a shadow title, aka legal title by characteristic, the lower quality legal title by characteristic is extinguished. When lawful consideration is tendered, the credit, fiat, title is extinguished, okay? When lawful consideration, what's lawful consideration? Silver, baby. Silver, 371.24 grains, all right? Find you some silver, okay? When an equitable asset of substance is moved to a legal title by characteristic, the legal title is extinguished. Your signature can be noticed to be an equitable asset, those assets that can charge in the eyes of equity, okay? When a trustee becomes the beneficiary, the duty is extinguished. When notice of an equitable claim over the same subject matter is not rebutted by the proper notice, Gibson waiver consent priority. At law, a trustee, a man cannot be his own creditor or debtor. Hence, when he acquires an estate subject to charge in his own favor, the charge will, in law, merge in the estate. Van Omer's estate, 25 PA, subsection 234, 237, Corpus Juris Secundum Estates. Also, you can be a debtor to your own estate. Georgie C. Bagley versus McCarthy Brothers Company, June 23rd, 1905. Minnesota's Reports, Volume 95, book page 289, merger. A merger at law is defined to be where a greater estate and a lesser coincides and meets in one and the same person. Coincides in one or... Okay. Less coincides and meets in one and the same person, in one of the same rights, without any intermediate estate. The less estate is immediately alienated, or in law phrase is said to be merged, that is, sunk or drowned in the greater. All right. Gilbert Law Summaries Trust, subsection 159, where a sole trustee or a sole beneficiary are one and the same person, the result of the merger of legal and equitable titles defeating the trust and creating a fee simple in the person, interest must be exactly the same for the merger to occur. Rights are said to be merged when the same person who is bound to pay is also entitled to receive. This is more properly called a confusion of rights or extinguishment. Gibson, subsection 55, suits in chancery where there are equal equities, the first in order of time shall prevail. He who is prior in time is superior in right. The maximum is sometimes misunderstood and misapplied. Its true meaning is this: as between persons having equitable interest only, if their interests are in all other respects equally, priority in time gives superiority in right, and in the contest between persons having only equitable interest, priority of time will give superiority of right, provided there is not other sufficient grounds or preferences between them. For if the equities are equal and one of the parties has, in addition, the legal title, then another maximum would apply. Where there is equal equities of the law must prevail, and in any court of chancery, in a conflict of equities, the party having the superior equity will prevail. And if the equities are equal and neither party has the legal title, then priority prevails, and if no priority, the defendant prevails. Grantor-grantee relationship. Absolute title passes both assets and liabilities, the entire ledger. You can't force someone to be the grantee, but an implied grantee with status, lawful consideration, and notice can force an operation of an assigned title to be an absolute conveyance, but you can make someone an implied grantor and make yourself a grantee where operations of law is otherwise determining the relationship. The reason you can do this is by maximum expressium factis, Latin. We'll read it in English. That which is expressed makes that which is implied to cease. Okay? Implied trust means there's an implied grantor, settler, trustee, beneficiary, implied trust without using the word trust. The mortgagor-mortgagee relationship and equity of redemption. What is a valuable consideration for a mortgage? What did you receive for what you gave? Loan application, notice of approval, they are holding credit assets, grant, deed, lien, mortgage contract, note, clogging provisions, landlord-tenant relationship, improvements, man security. Pomeroy, subsection 1192. A court of equity will look beyond the external form at the real relation between the parties and will protect the debtor's equity of redemption, if necessary, in opposition to the literal terms of the instrument. The principle lies at the base of the entire equitable doctrine and is applied to mortgages in the ordinary form to deeds with a separate defeasance to deeds absolutely on their face. Two deeds which accompanying agreements to reconveyance to reconvey, and to every other form of assurance which is in reality a security. Subsection 1192 is the instrument the instrument be in fact a mortgage. It is entirely immaterial that there is no provision for a redemption or no day fixed for the payment. Subsection 1196, whenever a deed absolute on its face is thus treated as a mortgage, the parties are clothed with all the rights, are subject to all the liabilities, and are entitled to all the remedies of ordinary mortgages, mortgagors, and mortgagees. The grantee may maintain action for a foreclosure, the grantor's equity of redemption. The grantor may maintain an action to redeem and to compel a reconveyance upon his payment of the debt secured. If the grantee goes into possession, he is in reality the mortgagee in possession, and as such is liable to account for the rents and profits. The mortgage, its original history, page 454, the law holds a mortgagee in possession to the fiduciary character, duties, and responsibilities of trustee, and compels him to account to the mortgagor as though the mortgagor were his cestui trust. Much of the difficulty in establishing a uniform rule grows out of the fact that a mortgage has been differently considered in courts of equity and courts at law. In the former, it is merely a security for money. In the latter, it has been considered as a conveyance upon condition. There is such manifest justice in the equitable doctrine and all its incidents that it must ultimately prevail. A treatise on the American Law of Real Property, Volume 2 by Emory Washburn, Section 6, Merge of Interest. It is generally true that whenever a legal and equitable estate in the same land come to one person in the same right, without an intervening interest outstanding in third person, the equitable merges in the legal estate, and the latter alone remains subsisting. But in order to work a merger, the mortgagee must be the holder of the mortgage at the time he acquires the estate of the mortgagor. If he has parted with that, there would be no merger by his coming into the place of the mortgagor. In applying this principle to mortgages, it makes no difference whether the mortgagor or his assigns pay off the mortgage or take the assignment of it, or the mortgagor conveys the mortgagee to the mortgagee by an absolute deed. Such merger extinguishes the mortgage debt, and the mortgage can no more be set up than if it had been fully paid. And a release of an equity of redemption operation as an extinguishment of the equity of redemption, and not as a merger of the estate conveyed by the mortgagee or by the mortgage. What constitutes denial of civilian due process? A clause of equity of redemption, denial of recognition of the deed absolute, versus statutory redemption, 8th Circuit Court of Appeals, District of Minnesota, 072079. Reports of cases adjudicated and determined in the Court of Chancery on book page 769. Note, as between grantor and grantee, the grantee becomes principal debtor and the grantor is his surety. Abbott's Digest of all the New York reports with tables of statutes, page 220, 17. The grantee under the conveyance styled and indenture, those signed only by the grantor, which contains a clause to the effect of the conveyance, is made subject to a mortgage, which the grantee assumes and agrees to pay, becomes bound upon acceptance, and the deed as covenantor to pay the mortgage. All right, that was a lot of reading. I hope you guys got something from that. My eyeballs, I don't know if you can see them, they're hurting. So, thanks for joining me. God bless y'all, and If this helped you out, make sure to give me a thumbs up on the video. Thanks.